Acceptance. We'll continue on, and what we want to be able to do is recognise acceptance in the wild. So, in order to actually reach an agreement, we need an offer. The offer needs to be accepted, and the acceptance needs to be notified. Pretty easy equation, really. And already in my diagram, you'll see that I have added in a little bit of additional language while the offer is still open. So again, once the offer has been revoked, it's no longer possible to accept it. In order to have an agreement then, we need an offer. The offer needs to still be open when it's accepted, and the acceptance needs to be validly communicated. So legally communicated in some way. So an acceptance is an unqualified assent to the terms of an offer that is still open. Why does it need to be unqualified? Because otherwise it's a counteroffer. That basically the way the rules work is we need to have an offer. The offer meets acceptance, no change. So the offer, remember that language we had last week from the American Code, it needs to be a signal of the terms of the deal on which someone agrees to make a promise, and it be understood that assenting to that creates a binding agreement. So the assent needs to be unqualified. In a bilateral contract, acceptance is the making of a promise to the offeror. So it's, and when you think about it, and we'll talk about consideration more, but the offeror says, I'll do something on these terms, and by accepting, the offeree says, I accept those terms, which in turn mean the offeree is making a promise to do the thing that is the terms on which the offer is made. In a unilateral contract, acceptance is by performing the acts specified in the offer, and we use an objective approach. Nothing new under the sun. Issues that arise in relation to acceptance include the kinds of things that are on this screen. I'll walk away from it so I can see it and not say them in the wrong order. So, one of the things that happens from time to time is who can accept the offer. Do you remember the general principle that we had earlier? An offer can only be accepted by the person to whom it is made, or the class of persons to whom it is made. Issues arise around whether we can determine whether acceptance has actually happened or not. We will spend a bit of time, I don't think we'll get to it this week, but we'll start thinking about whether there needs to be an actual meeting of the minds, or whether there just needs to look like there's a meeting of the minds. What happens when somebody signs a document that they haven't read, for example? What happens if an offeree accepts when they're mistaken about what the offer is, what the terms mean? Issues also arise when the correspondence between the parties or the communications between the parties are confusing or lacking, and working out which bits of communication go to the contract at hand. We need to think about also what amounts to an acceptance. Do you actually have to use your words, as we've all said to a 3-year-old at some point? What happens if you are silent but there's some sort of other conduct? And we've also used this word, acceptance needs to be communicated. So how is acceptance communicated? What's the general rule? Some of you have already got yourself completely flambusted by the postal rule, and then electronic communication. So thinking about the type of communication and how an acceptance moves forward. So, Taylor and Johnson, we use an objective test to identify whether or not acceptance has happened. So the court asks, would a reasonable person say that the parties intended to enter into an agreement? And the reasonable person is a reasonable person having the same information as the parties that we're dealing with. So Acting Chief Justice Mason and Justices Murphy and Dean said in Taylor and Johnson, the law is concerned not with the real intentions of the parties, but with the outward manifestations of those intentions. Doesn't matter what you actually thought, doesn't matter what you actually meant, what matters is what it looked like you thought or meant based on your behaviour. Oh. Sorry about that. So there are some rules. Here we've got a slide. You know, occasionally I like to whack in a slide that you might like to pull out later for exam notes, just so that you can't say I didn't give you anything at all. So, carbolic smoke ball. Offers can only be accepted by persons to whom the offer is made. Big part of the dispute in carbolic smoke ball was saying, we didn't even know about Mrs. Carlhill, we couldn't identify her. The rule is offers can only be accepted by the people to whom they're made. Court said, actually, you were making an offer to the world. She fell within the class of people who were able to accept your offer, being classes of people who read that newspaper and who could go to wherever a carbolic smoke ball was sold. The offeree needs to have knowledge of and act in response to the offer. So Crown and Clark is, actually I think we get to this in the slides. We'll talk about Crown and Clark later. It's a nice little case. The acceptance must be communicated, mostly. So we'll look at LaTeX and finance, and we'll talk about that case specifically, so I won't spoil it now. And silence by itself cannot be stipulated as a method of acceptance. So if I don't hear anything from you, I will assume we have a deal. Doesn't work. Actually, it works all the time, but it's actually not legally enforceable. So there we go. So what are some of these rules? The offeror can waive the right to be notified. So again, going back to Carlhill, one of the carbolic smoke balls arguments you will remember is, even if we made an offer, and they were saying that they didn't, that offer was never accepted, or that acceptance was never communicated to us. And in carbolic smoke ball, the court said, well, actually the nature of this particular unilateral offer is it wouldn't be practical for everybody to accept. They only need to notify that they've accepted when they've met the performance condition, which in that particular case meant getting the flu. If there is a method of acceptance, it needs to be in accordance with the method stipulated if there's an only method. So the only way you can accept this contract is by filling out this form and returning it to me, or you our offer will only be can only be accepted in writing, can only be accepted by email. The first person to telephone this number and accept this offer will be the purchaser, successful purchaser. All of those things are ways of stipulating a single method for acceptance. But if there is no method stipulated, then any equally prompt method is valid. So usually your assumption will be, if I send you a letter with the offer in it, that acceptance would be acceptance by letter is an equally prompt method. But acceptance by email would probably also be acceptable. Acceptance by carrier pigeon or nomadic warrior, which takes if there's anything that takes longer than the post, does anything take longer than the post? I don't know. Maybe not an appropriate method. And acceptance occurs when and where the offeror receives or is deemed to receive acceptance. This is a really important matter. So it doesn't matter when you actually accepted. What matters is when the offeror receive notification of the acceptance. Acceptance, however, can be inferred from conduct. So shaking hands, nodding, emphatic yeses, dancing at an auction when the price, if something's handed over to you, all of those things might be conduct that from which your acceptance of the term can be inferred. On an objective test, conduct including silence can still indicate acceptance. So being in the same, it's one thing to say, to write a letter that says, and in Feldhaus and Bindley, the uncle had written a letter that said, I'll pay blah, blah, blah for the horse. If I don't hear anything from you, I'll consider it done. But that's quite different from being in a room and saying, if you're happy with that, we'll just move ahead. I don't need to hear anything, but say no now or never forever hold your peace. Your silence then could be inferred as an acceptance because you had the opportunity to reject. And where we finish up with acceptance is dealing with the difficult cases where you can't necessarily see one offer and one acceptance, where you can't necessarily see an immediate meeting of the minds, particularly in there are two kinds of cases here, the Brambles cases and then cases, the battles of the form cases like FCL and Butler Tools, I think it is, where you've got two slightly different but corresponding documents. So over time, the courts have taken a subjective approach, but more and more recently, they have moved much more towards the objective approach. So an objective approach really looks only to the external manifestations of consent. It disregards an offeree's actual frame of mind. I think these days, the likelihood of a subjective test being used by a court is so minimal that it's really of historic interest only that in the very ancient cases there was some kind of subjective understanding. But still, we look at cases like Carlhill, for example, is a case where there was, to an extent before the communication, I got the flu, there was this idea of a potentially subjective assessment or objective acceptance. Excuse my tongue-tiedness. So, Taylor and Johnson, we've used this quote before. Would a reasonable person, having regard to their external manifestations of conduct, consider the parties to have reached an agreement? Would a reasonable person, looking at what the parties are doing, have assumed that the parties have reached an agreement? So Taylor and Johnson. So this is one of the cases, particularly goes to, well, what happens if you are mistaken as to what it is that you think you've accepted? So Mrs. Johnson had two adjoining lots of land. They were about 5 acres each. They had a particular value, and Mr. Taylor was aware that there was going to be some sort of rezoning, and he was aware that it was going to markedly impact the price itself. So Mrs. Johnson granted an option to Mr. Taylor to purchase the land for a total price of $15,000. Number one, that was under the market value of the land. But secondly, Mrs. Johnson was of the understanding it was $15,000 an acre, not $15,000 all up. And Mr. Johnson understood, he actually contributed to her misunderstanding, and he was also very much aware of how the property value could go up. So he exercised the option. Then sometime, I haven't never really got my head around the facts, but basically Mr. Taylor and Mrs. Johnson died. So it's basically their estates are having this battle in relation to whether or not the Johnson estate was actually legally bound to transfer the land under the auction. So Mrs. Johnson or her estate refused to perform the terms of the contract because she believed she would be getting $15,000 an acre, $150,000, not $15,000 all up. So the issue at stake here was whether there was an agreement or did the mistake, so her failure to understand what the contract or what the offer was, did that vitiate in some way her acceptance? So the court found that it's not the subjective beliefs or understanding of the parties about their rights and liabilities that govern their contractual relationship. What matters is what the party, by their words and conduct, would have led a reasonable person in the position of the other party to believe. So in other words, Mrs. Johnson, if you look at it objectively, the words on the piece of paper were clear. $15,000 all up. She signed the contract. She signed the option. In other words, she loses. But you're saying, but Kath, I know that Mr. Taylor didn't get the land. Why is that? Why is that? So, using an objective test, there was an acceptance in a contract. But at the end of the day, the order of specific performance wasn't given. Do we understand why? The order of specific performance is an equitable remedy. Equitable remedies can only be given to people who come with clean hands. So Mr. Taylor was stopped from being able to exercise his rights under the contract because he had contributed to her misunderstanding and her mistake. So if her mistake had just been her mistake and he hadn't contributed to it, he would have won. But ultimately, he won on the point of law. Yes, there was a contract, she had accepted it, but he lost. So he won the battle but not the war because equity would not assist him with that particular remedy. Questions, concerns, frustrations? Sarah?
Is it more about a misunderstanding that it was 15,000 total, not per acre, rather than the rezoning, which is more of a...
Well, it's a combination from the estoppel point. The estoppel point went to he had contributed both to her understanding of what the contract was worth. So he had his language and actions, he knew that she thought it was 15,000, or 150,000 would be the outcome, but he knew the words said 15,000 all up. So there was that point. There was also the fact that he knew about the rezoning and he'd taken steps to hide that from her. So, but then he was making uber profit. So he was about to make a $45,000 profit based on her understanding of the bigger picture, but then he made even more profit than that, or would have, because he contributed to her misunderstanding of the contract. Ellie? Yeah, he didn't act in good faith. So he wasn't coming to equity with good, clean hands. So now that doesn't always, never ever tell your client, oh, just sign that and then later on we might be able to argue that the other side didn't come in clean with clean hands. We'll look for an estoppel. You know, it's not a remedy to rely on, let me tell you. But, you know, sometimes the point is harsh, but the execution is less so. Then other times the point is harsh and the execution is equally harsh. So, yeah. Important point here is the ultimate decision was based on a completely different point of law. But Taylor and Johnson is good authority for the use of the objective test. Fitness first and Chong. This is not a case of particularly high probative value, but it's, I don't know, I like this case partly because my friend Lisa Fong, and it's not even Chong, but it's Fong, so it works for me. She and I make resolutions to join gyms every year, and I know she actually does it. I don't even join, like I'm so bad, but she actually goes and joins them, and I'm sure that she just, like, they just keep her money every year. And I just think this is such, I can just imagine doing this. So Mrs. Chong went into a gym And she signed a form and she bought a 12-month membership. She didn't read the form. She didn't read that there was a cancellation form. A few weeks, months, I think it was within the first it was within the first 2 months, she went and cancelled the membership. She'd never been to the gym. And they said, $200 please. That's your cancellation fee. She said, no, I've never been to the gym. I don't owe you any money at all. And they say, well, you should have read the fine print before you signed it. So there was an action. I think this is in VCAT, actually. It's not of particularly high probative value, as I said. I haven't got my notes in front of me because of the way I have to set up the slides. 90-something? No. 2010-ish is my guess. You can have a look. It hasn't got a proper citation there. But the question before the courts was, okay, there's no argument that she didn't sign the contract. She signed the contract, but she said, well, there's no meeting in the minds. I was not aware of that clause. I did not read that clause. Now, there is a case of significantly more probative value that will help you here. One of the most cited cases of all Australian law, which is Cadelpha, and it draws on a very 1950s case, I think it is, which is referred to as the rule in Lestrange and Graucob. But I just like the facts of this one, though. There's nothing controversial in particular. So, but what do we think? Given that agreement is about a meeting of the minds, we've got an offer and it's accepted. The offer contains all of the DNA of the deal. So Fitness First have got an offer document that's all written down, and all she had to do was sign it, but she hasn't read the terms. So how is there a meeting of the minds in relation to that? What do we think? Who wins? And why? Fitness First, they did win. Why did they win? Because their guys were musclier?
They both looked like they were intending to be bound by contract.
Objectively, but I mean, at the end of the day, I work for Fitness First, right? You can see this. Come out with me. Let's role play this. Okay? It's about time we had a role play. I'm at Fitness First. I come in, I say, I want to buy a membership.
Aren't you at Fitness First?
Oh, well, which way? Who wants to be Fitness First? It doesn't matter.
I'll be Fitness First then.
Yeah, you're at Fitness First. Because look at me, I'm clearly the one who needs the fitness stuff. So I've got I want a membership. Are you going to make me read those terms?
That would define make.
Well, how do you reckon that plays out? How do you reckon that plays out?
Here's the terms, please have a great read. I'll make some protein shakes while you read them.
How likely do we think that scenario is? What is more likely to happen when I come into Fitness First? I'm thinking about joining.
Here's a free backpack.
Yeah, ace. What else?
Join up.
Okay, where's the form?
Here it
Oh,
is.
no, well, I'm not asking you, just getting me a form.
Yeah, if you sign now, you get a towel as well.
Oh, awesome. Off I sign. There we go. There's no telling me to read it, right? In reality, no, I mean, I love the way that you did that. I think I'll go to your gym. I'll send Lisa there, actually, because like, the reality is she'll be out. But every New Year's Eve, I tell you, every New Year's Eve we talk about this. But yeah, objectively, if you looked at the scenario, there was no basis on which anybody was alleging that Mrs. Fong had read the terms and conditions. She was just given a form. So if we can't objectively see from her conduct that she read the terms and conditions, how do we know that there's a meeting of the minds? Why do they win? I think it's the right decision, by the way. And I think there's really good arguments for why it should be the right decision.
But isn't her conduct of signing the form indicates that she is objectively...
Exactly. You can lead a horse to water, but you can't make them drink. It looks like a contract. It's a form, but it looks like a contract. It is reasonable to assume that if somebody is promising you services in exchange for cash and they give you a form to sign, chances are that there are some obligations in it for you and some limitations of liability for them. And if you don't read it, you don't know what that terms are. That form most likely said if you happen to slip over on a sweaty mat and hit your head on a dumbbell, we are not responsible. In addition to, you're going to have to pay us money if you quit early. James?
I think I recall reading, maybe it was in the introduction to the textbook, but there is some slight movement on this point recently because there's so many...
There's quite a lot of movement in this point in relation to what are called standard form contracts, and in particular the unfair contracts law regime, which we will talk about at some length in, I think, our 11th week together. But in relation to the principle around, and it needs to be a standard form contract, which quite frankly this one probably was, but even so, a $200 payment when I've got a free backpack and a towel and the opportunity to drink a protein shake, I'm not sure that the contract would have been problematic. So basically it was a tribunal, can't remember the year, good call. I'm sure that the citation is available to you somewhere. That the parties initially, so the tribunal said, well, we don't have consensus ad idem. We don't have a meeting of the minds, so we don't have an agreement. But on appeal, that was overturned. So the general rule is a person who signs a document which is known by that person to contain contractual terms and to affect legal relations is going to be bound by those terms. So many of us think when we're signing a Form 2, particularly when they're forms, they look like they're non-negotiable. So you just sort of accept and you think, oh, I've got no choice. And that may or may not be true. But, you know, forms that are on a take it or leave it basis are filled by this, this regime. Where are we next? So fitness first, finished up.
On the editing the form, if you don't like the clause, if, for example, she crossed out the $200 cancellation fee bit, would that then be up to Protein Shake
Well,
to take note of that?
Yeah, let's think about what that would be. If you gave me that form, I read it, I've crossed it out and given it back to you, what have I done?
Counter offer?
I've made a counter offer. So then the question is whether or not you accepted that counter offer or not.
So how would they show acceptance though, being a gym? I guess giving you your...
Well, at the end of the day, it seems to me on an objective test that if I'm able to, if you've got the right to give me the form and basically accept me, to make an offer to me, you probably have the right to bind the gym, and it would be reasonable for me to assume that you had authority. That's something you'll deal with when you talk about agency in some sort of commercial law context at some point. I am aware that it is now just shy of 8:20, and I always try and finish, if I get to the right spot, in time for you to run to trains. So I am going to finish here. We've got a bit more on acceptance to do next week. Please, I know you will have an assignment due at the end of next week, right? But still come to class because you will not make the time up in other ways. If you can make it, have a good week, people. You know where to find me if you've got questions. Same for you at home.